your long time passion and leadership for protecting our people from the scourge of gun violence. Mr. Horowitz, we passed a red flag law in Rhode Island. It went into effect in June of 2018, and the last report I have ends with that as of November 2019. In that period, state and local police in Rhode Island invoked that law 33 times. In one of our municipalities, Cranston, police petitioned for red flag orders 8 times, just in one city. In one case, police seized weapons and obtained an order to help a worker who had made comments he had a desire to kill certain coworkers and had boasted about his firearms. Is that experience in Rhode Island consistent with what you see around the country in terms of the
I think
laws
it is.
being made effective?
I think it is. I mean, I think we're seeing it used very judiciously. I think we're not seeing, millions of these being done. I think, there's in Virginia where I'm very familiar, there's under 70 or so, even in the first year. So I think it's very consistent with what we're seeing around the country. California in the first couple of years saw under 400 in such a big state, but they're very important. They're based on someone's, on the risk of individuals. And I think that's why they're not used for mass, for lots of people across a wide spectrum. They're individualized attempts to identify people who are at an elevated risk of violence. And I think that's why they're important, that's why they're constitutional, and that's why they're effective.
Ms. Wyatt, those of us who've sat in a prosecutor's chair and had to make the decisions that you have to make are familiar with a whole variety of legal procedures that help protect people from threats of violence, whether it's restraining orders, protective orders. They're particularly common in the domestic violence arena. In your view, are the protections involved in the red flag laws consistent with those for other types of safety orders that law enforcement commonly obtains?
Thank you for the question. Yes, you're exactly correct in that extremist protection orders follow the process similar to domestic violence protection orders or sexual assault or anti-harassment orders, meaning that each phase comes before a judicial officer. So a family member cannot walk off the street and get an ERPO on their own, nor can law enforcement. They have to sign and fill out a detailed petition signed under penalty of perjury, and then it's submitted to the court just like any other civil order would be. And the court is making a determination if they're, in our state, reasonable cause that the individual is a significant danger to themselves or others. So it's a similar process with other civil protection orders as well. And then the individual subject to the order has to be served, because that individual needs a chance to be able to come to court, to have their own witnesses, to be able to tell the court either they're in favor of the order or they're going to challenge that order. So each phase and each step involves judicial oversight.
In particular, Ms. Wyatt, do you think, just as a matter of good practice, it would be advisable to have domestic violence victims or those who have a restraining order protecting them from another individual be advised when that individual, their assailant or the threat to them, acquires or tries to acquire a weapon, a firearm specifically?
Yes, and our unit specifically addresses not only extremist protection orders, but of course also domestic violence protection orders. And because the lethality is so high at the moment that those victims are petitioning for separation or petitioning the court for a domestic violence protection order, it's critically important that we follow up and enforce court orders when they're ordered to surrender weapons, like in our domestic violence cases, or ERPO. And our state has a system set up to notify if somebody is subject to an order and somebody attempts to purchase or if we get notification from our state patrol, and then it goes to local law enforcement as well as our unit. And then we have victim advocates that are reaching out to the victims as well to make sure that they know that there is either an attempted purchase, or if a firearm was actually delivered, then we're going to be following up with local and federal authorities if we believe that the firearm was given to somebody who should not have it.
If I could ask one more question, Mr. Bencomo.
Sure.
I think it's human experience that powerful emotions can pass through human beings, anger, rage, jealousy, and that the decision-making during that period when you're in the grip of a fierce emotion can be compromised, and the people act out in unfortunate ways in that moment and make decisions sometimes that have irrevocable consequences for the rest of their lives. Given that aspect of human nature, is it conceivable that the subject of a restraining order, the person who is told they have to take a pause on having their firearm, is actually the real beneficiary of that restraint?
A simple response would be yes.
Yeah, it just seems that way. You lose your access to your firearm for a week or two, and you're spared a lifetime of guilt and remorse, and the horrible memory of having acted on something when you were in a fit of emotion. Seems that way to me anyway. Thank you.
Thank you.
Thanks, Senator Whitehouse. I'm going to call on Senator Lee. I'm going to vote